Hello students, welcome to Legacy IAS Academy. Today we are going to discuss about the section 144 of the Criminal Procedure Code, when it can be used and what are the possible criticism of this particular act that has been enacted during the British time in the colonial era. So first of all, let us try to understand about the context in which we are discussing this particular issues. Is recently because the administration of Uttarakhand's Haridwar district on the Tuesday, that is April 26, they have imposed prohibitory orders under section 144 of the CrPC 1973. It has been imposed in an area up to 5 km around a village called as Dada Jalalpur near the town of Roorkee. So why this particular act or section has been imposed? If we try to go in the background of this act, background of this incident, so it has been imposed because the Supreme Court has actually instructed the Uttarakhand government to give a commitment that such incidences which are untoward situations or unacceptable statements will not occur in the Mahasabha that is going to be held in the coming days. The reason behind this direction is because similar Hindu religious Mahasabha that was held earlier in last month, there was instances of incendiary speeches against Muslims, and that has been made by Hindu religious leader at such gathering previously. So to prevent such incidents to occur and to prevent kind of communalism or development of communalist feeling in the country or in the region, the Supreme Court has directed the government to take that measures. Now let us try to understand that what is the section 144. So section 144 of Criminal Procedure Code actually gives a right to either district magistrate, subdivisional magistrate or any other executive magistrate that is empowered by state government to take certain actions. What can be these certain actions? So these officials can issue orders to prevent and address urgent cases of apprehended danger or nuisance in the future. Apart from that, they can also direct section 144 can also be directed against an individual or any individual that is residing in a particular area or to public at large. So it can be individual specific as well as to the public specific. Apart from that, magistrate can also pass the order without giving prior notice to the individual targeted in the order. That means magistrate does not have to necessarily inform you can say this individual who is targeted by section 144 before. Once it has been imposed, then also the magistrate can then inform him, or the concerned official can inform him. That is about section 144. So what are the powers that is given to these officials under section 144? So first of all, these officials can direct any person to abstain from certain act which they are planning to undertake. This can be holding rallies, or this can be, we can say, if having a kind of meeting with a large group of people, or any such acts, violent or non-violent, they can be curbed or abstained from certain acts. Apart from that, the second power is that these officials can also pass an order with respect to a certain property that is in possession or under the management of the person who is being targeted by section 144. And third is the officials can also impose restriction on movement, carrying of arms, as well as any kind of unlawful assembly in the concerned region where section 144 is being imposed. Here it is conventionally observed that when we talk about unlawful assembly is generally when more than three or more persons are actually coming together for certain acts that is prohibited by the imposition of section 144. So these are three major powers given to the executive magistrate or other concerned official. However, this imposition of section 144 cannot be arbitrary. So there has been certain grounds that has been entailed on the basis of which section 144 can be imposed. So first of all, it can be imposed by the magistrate if the magistrate believes that in the particular area there is likely to be certain acts, and these certain acts need to be the section 144 need to be imposed to curtail the certain acts, so that prevent obstruction, annoyance or injury to any lawfully employed person. Apart from that, magistrate can also impose section 144 if he feels that there is a danger or threat to human life, health or safety, or a potential disturbance to the public tranquility, or a commencement of right is very feasible. And if you look at the period up to which section 144 can be imposed, so as per the law, it can be imposed at a single stretch up to 2 months, which can be further extended by the state government if necessary. However, there is a limitation that section 144 can maximum last up to 6 months. It cannot be stretched in single stage for more than 6 months. So obviously, since this particular section 144 is imposed to ensure that public order is maintained, what are the criticism of this particular section? So first criticism is by the civil society especially is that such laws or such sections allows a wild unwielding power to the magistrates and officials, and thus they are able to exercise absolute power without any justification. Second, it also criticism lies in the fact that there is a remedy. What has been suggested in this particular law is that if someone want to complain against section 144, first he need to approach the same official who actually has imposed section 144. So there is a kind of conflict of interest, and that is why the first remedy against section 144 is considered as a toothless. Then third, after the first remedy, the petitioner can also approach the concerned High Court to ensure that writ petition is issued by the High Court. However, the problem is writ petition can only be issued if fundamental right of any individual is being violated. However, the problem lies in the fact that by the time the individual or petitioner goes to the High Court, his fundamental right would already have been violated. So it is kind of ineffective that the writ petition, the use of writ petition becomes largely ineffective. And fourth criticism is over the area of imposition, because many times, as we have seen in the earlier cases also, government imposes section 144 in a very large area despite the possibility of disturbance or actual disturbance happening in a very small area. So thus, because law and order situation, security situation varies from place to place, thus imposing section 144 in a very large district or even in the whole state actually is criticized. Then coming to what has been the traditional stand of judiciary on the particular section 144. So the first matter that went to the court was in the pre-independence India in the year 1939, when we have a very famous case called as Ardasir Firoz Shah versus Unknown. However, there has not been any significant outcome or judgment from this particular these cases. Then second important development happened after independence in year 1961, when we have a very important case, that is Babulal Parate versus State of Maharashtra and others. However, as per the High Court judgment, the Bombay High Court says that it is not correct to say that remedy of a person agreed by an order under the section was illusory. If I try to put your attention back, few minutes back when I discussed about that, one of the major criticism of this particular section is that the first remedial action is toothless and also the writ petition is kind of ineffective. However, court did not agree with this viewpoint and says that it is not the case, it is not illusory. There is actual and we can say real possibility of curative action to be taken if section 144 has been enacted or imposed in unjustified manner. Then third case came to light in year 1967 when a petition was filed by the socialist Dr. Ram Manohar Lohia in the Supreme Court. However, Supreme Court, Ram Manohar Lohia actually wanted to abolish section 144 and quash section 144. However, the Supreme Court did not agree with his view and they gave a statement that is no democracy. Since we have discussed section 144 is largely to ensure that public order is maintained in the country. Thus, Supreme Court observed that no democracy can exist if public order is freely allowed to be disturbed by a section or group of the citizens. And thus, the imposition of section 144 is not unconstitutional and thus should not be quashed. Then next important judgment came 3 years later in the 1970 when we have a very famous case of Madhu Limaye versus Subdivisional Magistrate. The case then went to the Supreme Court under the, we can say the judgment was given by Justice M. Hidayatullah, and Justice M. Hidayatullah has made certain observation. The first observation he made was regarding to the power, with regards to the power of magistrate, where he has observed that power of magistrate that is given under section 144 is not an ordinary power flowing from administration, but a power used in judicial manner and which can stand further judicial scrutiny. That means if court wants or if court feels that there is a need to scrutinize the action taken by magistrate, then it is free to do so. The second observation that was made is that this section 144 falls under the reasonable restriction that is given to the fundamental rights laid down under Article 19, subclause 2 of the Constitutions. Thus, the imposition of just mere imposition of section 144 on the valid grounds does not counter or does not curtail the fundamental rights under Article 19(2) of the Constitution to any citizens of the country. And third, he also observed that just because there is a possibility of law to be abused or misused, it is not a valid reason to strike it down, because then this will be true for any law that has been implemented or has been enacted in India, because any law has the potential to be misused by the authority wielding the power. So these are three major observations, and pointing to these three observations, the Supreme Court then rejected the petition to quash section 144 once again. The most recent judgment have come from the Supreme Court in year 2012, when Supreme Court has made these observations that such a provision, just because the magistrate holds the power to impose section 144, it does not mean he is free to do so on his whims and fantasies. Such a provision can only be used only in grave circumstances for maintenance of public peace, not in another case. Apart from that, the Supreme Court also observed that the efficacy of the provision is to prevent some harmful occurrences immediately, and therefore the emergency must be sudden and consequences sufficiently grave to justify the imposition of section 144. So these are certain guidelines or safeguard that has been suggested by Supreme Court, and also we can see the steps that has been taken by Supreme Court so that the power of imposing section 144 is not misused. So that is all about this particular issue. I hope you understood about this section 144 well. That is all for today. Thank you very much.